Council business. Council and civic engagement training on the Brown Act. David.
Good evening, Madam Mayor and members of the City Council. I've been asked to provide an update on some recent legislation to the Brown Act as part of city's commitment to provide education to the City Council and to the public regarding the laws that govern our business. So I did compile a short presentation. I'm going to go into depth on the new teleconferencing rules and a little bit on the social media rules, which were updated in 2021, which are a little unusual. So I wanted to give a refresher. But before that, I want to show you how many offices we have, right, with this slide. And just start with some history. We actually kind of have the league to thank for the Brown Act. Back in the 50s, I think the idea was they better get on top of this before the legislature does itself. So actually it starts, it really comes from this report out of the Chronicle about your secret government that led to what was then a relatively short, I think it was like 3 pages of legislation. It's now quite a bit longer. Most of the questions about the Brown Act are really animated by the purpose of it, which is that the public's business should be done in public. And so as a result, one of the primary things that the Brown Act does is it regulates when a meeting of a local legislative body can occur. And it provides this definition on the slide for what a meeting is, at least in part. So there's 3 main components. It's got to be open and public. Oh, actually, wait, this is the purpose. This is the meeting. So it constitutes a majority of the members of the body. So for purposes of the City Council, that's 3. For larger agencies, say some LAFCOs have 7, and then you got 5, right? 4 for a majority. Hearing, discussing, and deliberating on a matter. So it's not just voting on something, it's just talking about something. And what is that something? Well, it's something that's in the subject matter jurisdiction of the legislative body. So when you're talking about, what you had for dinner last night, that's not really in the subject matter jurisdiction of the body. But there's something else that's a meeting, and just as a reminder, a series of communications of any kind, also called the serial meeting, can also be a meeting under the Brown Act. Essentially, even if you're not all together in one place at one time, if A is talking to B and B is talking to C, that series of communications, even if it's not happening simultaneously, also constitutes a meeting. And why? Well, if you think back to the purpose, you're potentially doing the public's business, but you're not doing it in public. Meetings have to be at a noticed and open forum. So those serial meetings, we kind of talk about them. And those of you who are more familiar with the Brown Act will be familiar with the hub and spoke. That's where the person in the middle of the hub and spoke talks to a majority of members of the council and imparts to each of those members the thinking and the deliberative process of the other council members. So once 3 council members all know what each other thinks about a particular development project or a particular contract that's being awarded, you've just had a meeting and it wasn't open in public. So that was a Brown Act violation. Daisy chain is what I described earlier. A talks to B, B talks to C, et cetera, et cetera. And these type of serial meetings can come up in serial briefings, emails, and social media. So I'll talk a little bit about those. And just a reminder that there are certain exceptions. Obviously, council members can speak to their individual constituents. There's no Brown Act violation involved there. You can go to conferences, you can go to community meetings that are open in public. You can go to the Board of Supervisors meetings, a majority of you can, and social and ceremonial occasions. The thing that's always important is that you can never speak with a majority of members of the legislative body about city business at those functions. And the other thing to remember is the perception issue, which is that even if you're all talking about the wedding of some, kid that you guys know, there may be somebody else at that meeting who sees that and assumes you're talking about city business. And so there's always a perception issue that that everyone has to be aware of. So getting more into our modern means of communication, email has become, and most of you are probably aware, it was a lot worse in the beginning when we first started using email, but it became a major source of serial communications. And we used to get a lot of questions, well, sure, but I'm copying all the emails to staff, or we will take all those emails and put them in the agenda packet afterwards. Is that okay? Doesn't that cure whatever problem? No, that doesn't cure anything. The Brown Act doesn't allow those communications to contain a majority of members of the legislative body. And that's just as true for text messages as well, which is why I mentioned that, because that's often now something that comes up. So you'll see if I ever email you guys, I'm going to use the blind copy function so that you can't accidentally reply all. So in 2021, AB 992 went into effect, and it revises this particular section of the government code, and it applies to essentially social media. It says any internet-based social media platform that's open and accessible to the public. So that's just about everything. Includes like comments, on a newspaper article or something like that. As long as it's free to register, then this applies. And the law says that your job in interacting with the residents, the businesses, the property owners, is to solicit information from them and find out their views on things. And so the Brown Act specifically says that is completely fine for an individual council member to engage in separate conversations or communications about district business if you're answering questions from the public, asking for information from them, or providing information about whatever the business of the city. So that's encouraged, and that's totally fine. However, AB 992 says that you cannot respond directly to any post that's made, posted, or shared by another board member, city council member, legislative body member. So unlike everything that I've just talked about, we are now not talking about a majority of the city council or a planning commission or whatnot. We're talking about two people. So even if you're, on LAFCO with a whole bunch of folks, it's still two people. You can't like another council member's post. You can't share it. That is impermissible, at least through, I think, 2026. This law sunsets and probably be superseded by a new law that's potentially even more stringent. So it's an unusual rule, so I just wanted to highlight it.
I really like the balloon picture.
Thank you.
Drives it home.
And again, that same admonition, you can't use social media to engage in a communication with a majority regarding city business. It's the same. That prohibition, of course, is the same as we've talked about. So if you guys have any questions or anything while I'm elaborating on, I'm happy to stop. All right, so that's a series of communications. So now we're talking about a meeting. Well, okay, so you can't have a meeting in cyberspace there. So where can you have a meeting? Well, the regular Brown Act rule says you have to have your meeting within the agency's boundaries, so within the city limits. And there are a few exceptions which are up on the slide here, which, personally, I don't know if I've ever had to do any of these, but they are permissible. Inspect real property, meet at a facility outside of but owned by the local agency. If you guys want to all come to my office for a closed session, I guess that's permissible. I hadn't thought about that, but I can talk to Kevin in the future about that option. But there are teleconferencing rules, right? And there's always been teleconferencing rules. I mean, we call them teleconferencing rules because that's the old way of talking about this, but essentially it's a type of hybrid meeting. So there's the standard or traditional Brown Act teleconferencing. When the COVID emergency began, the governor suspended a number of provisions of the traditional Brown Act teleconferencing rules. Those were then, for the most part, codified into AB 361, which is what we are currently operating under right now. And then just this past legislative session, the legislature passed AB 2449, which went into effect on the 1st. And I want to take some time to talk about that as well. So as a refresher, our standard teleconferencing, this is what we always could do before COVID, and we can still do it. It requires that a majority of council members be within the city. It requires that the teleconferencing location, so say one person is remote, that person has to be at a location that's also open and accessible to the public. The agenda has to be posted at that remote location, and the agenda has to identify that remote location. And you have to allow for public comment at that remote location. So it's somewhat arduous, and unlike what we've sort of become accustomed to with COVID, it was unusual for someone to teleconference from their home, because they would then have to list their home address on an agenda. And as you know, there is a privacy interest in that, and members of legislative bodies are not required. In fact, it's illegal for staff to disclose the home address of members of legislative bodies. So normally we saw it applied when somebody was on vacation in Hawaii, for example, and they still wanted to come to the meeting, and they were at a hotel, which should be ADA accessible because it's a hotel. So often you'd post the notice outside the front of the Hilton in Waikiki, and you'd have to list that on your agenda. Person would leave their door open in their room in case anybody wanted to come in, and you could have your teleconference. We can still do that in case anybody's going to Hawaii, so just let us know. When the COVID emergency began, they suspended a lot of those provisions. And with AB 361, which we're currently operating under, it has a number of provisions. First of all, it's only effective while the governor's emergency declaration is in effect. And as you probably all are aware, Governor Newsom has announced that his declaration will end at the end of February. So AB 361, even though it's still going to be in the statute, we won't be able to use its provisions. There were a number of other provisions. As you noticed, we've had to adopt resolutions making findings every 30 days. We had to include instructions for virtual attendance, which we do. If the broadcast is interrupted, we actually are supposed to stop the meeting. Fortunately, we have a really good IT that does not, so that hasn't happened. That wouldn't be the same with a teleconferencing, right? So if for some reason the person in Hawaii's phone goes out, as long as you've got a quorum here, you can still continue your meeting. And the public could, with AB 361, right, the public can attend from their homes, as opposed to going to the remote teleconferencing location. And if there is a council member at home who's using AB 361, they don't have to allow the public to come to their house. They don't have to post agenda at their house. And so this is sort of what we've been operating under more or less since the pandemic started. So AB 2449 basically says, go back to what you were doing before the pandemic, but we understand that sometimes things happen and life gets in the way. And if that does happen, then we can allow members of the city council to appear remotely without having to publish where they are and to post the notice, etc. It applies in two circumstances: when a council member can either show just cause or they have what's called an emergency circumstance. So emergency circumstance is a physical or family medical emergency that prevents the council member from attending. Just cause is a little broader. It includes childcare needs or other caregiving needs for family members. If you're sick, if you have some type of disability, or if you're traveling on official business. So unless we have official business in Hawaii, those rule, if you want to remote in from your vacation spot, you'd have to use the traditional teleconferencing rules, not these. I'm sorry that this slide isn't easier to see, but hopefully you can look at it in the packet. But what I tried to do here is identify the differences between our standard teleconferencing rules, AB 361, which is what we're doing now, and AB 2449. So with AB 2449, we're still going to have a majority in the council chambers. You're not going to have to post the requirements. Teleconferencing location. So unlike the standard rules, under AB 2449, if a council member wants to remote in, they have to use audio and video. They can't just call in. The old rule, the standard rule is you could just call in. You have to use both call in and video with AB 2449. And the public has to be allowed to, actually I'll get to that one. I don't want to get ahead of it. Yeah. So council members' method of participation, audio and video. Method of public participation under AB 2449, the public has to be allowed to address from a remote location. So similar to what we're doing now. You can't require comments in writing only. You have to allow them the opportunity to either use Zoom like we do. The other option is they could have a call in, but you have to then have a live web stream so they can see what's going on. So we don't have that, but that's the other requirement. Again, if there is a disruption in the electronic access, as with AB 361, we need to stop the meeting. And there's a couple things I wanted to mention on this slide as well that I didn't write. So this is a new twist. Apparently, there was some concern about council members of the Board of Supervisors, whatever, local agency members who were participating by Zoom, but who were potentially being, they were having some type of undue influence on them while they were in the meeting. Like somebody was in the room with them, telling them how to vote or something. So under AB 2449, if you want to remote in, you need to disclose at the beginning of the meeting who is in the room with you that is 18 years of age or older, and the general nature of your relationship with that person. So if your spouse is home, you need to identify that your spouse is with you. So that is a new thing. What constitutes room when usually you just see people going back and forth behind in and out of the room? I'm not sure, but I think you'd probably have to disclose who that person is if they're coming in and out. So that's an interesting nuance. And then with respect to the just cause and emergency circumstances, so these do need to be disclosed. If your reason for remoting in is because you have a caregiving need or because you have a medical emergency, you do need to disclose those to the public and to the council. You don't need to provide any confidential information that would be protected by HIPAA, but you do need to give the general nature of your reasoning. If you do a just cause, if you have a just cause reason, then you can just announce it and go forward. But if it's an emergency circumstance, it actually has to be voted on and approved by the council, the other members of the council. And the AB 2449 actually adds a new provision, which I've never seen in the Brown Act, which basically allows the council to take action on something that's not on the agenda. And that is a council member's request to appear remotely based on the emergency circumstances. So it's even if it's not on the agenda, that's going to be the first thing that we'd have to do. Basically, you need to provide this information as soon as possible. And there are even provisions that allow the disclosure of the reason to be in writing. And it's very similar. It's written very similarly to the requirements for agendas. So like 20 words or less or something. And then there's this annual limit on its use. So just cause, you can't use it more than twice. And any combination during a calendar year, and any combination of just cause and emergency circumstances, it has to be basically no more than 3 months or 20% of regular meetings, whichever is less. So essentially, if we have 24 meetings a year, that's 4 meetings total. You can use just cause and emergency circumstances only 4 times a year. So that's something that I think we'll have to have the clerk help track as we go forward. So it's a complicated rule. It has a lot of nuances. I didn't cover all of them. I think the takeaway, though, is that it's available for you if you need it. To a certain extent, I'd be surprised if somebody really does have an emergency circumstance that they would even want to be appearing for a meeting. But obviously that's not my choice to make, that's your choice. So it is something that we can, that is available as of now. I think most jurisdictions are operating under AB 361 until they don't have to, which will be through the end of February. And at that point, we'll see probably more and more people appearing under AB 2449. And honestly, a lot of people going back to the standard teleconferencing rules, because sometimes that's just easier, especially when you're not on official business when you're in Hawaii. So with that, I'd be happy to answer any questions, and I wish you a wonderful Brown Act experience.
Sure was.
Good update, especially the social media. It's like good to get a reminder on that. Any questions?
No.
Anyone from the public? Come on up.
So I have one question on social media.
Do you want to state your name?
Oh,
for the public?
Nathan Maxman.
There you go.
What if a resident were to make a comment that may or may not, that's gray, whether it would be under the jurisdiction, and 2 members of council or planning commission were to like it, not even knowing that the other one necessarily did? Would that be an issue?
Well, if it's a city council member and a planning commissioner, they're on different legislative bodies. So
But
that's
2 from the same body.
I think the way the statute is written, it's whether or not it's direct, you're commenting directly on another's post.
Okay.
So if the like is of the post or the share of another council member, then that would certainly be a violation, I think, under AB 992. I think it's probably prudent for planning commissioners to look at the chain of comments or look at the names of the people who've liked something before you decide to do that yourself.
Okay.
In order to avoid even the appearance of impropriety.
Thank you.
Councilor Carlett?
So let's say that you schedule the one and only week that you can, and you're in Vegas or Hawaii. And you want to participate on a particular item. Do you have the choice of standard or AB, you know, the second option, 2449, whatever it is? Or, I mean, if you look and say, I I notice the agenda and I tell them I'm in room 351 in, Las Vegas Hilton.
Yeah, if you're in Las Vegas and you don't have a medical emergency, a caregiving issue, you're not there on official city business, then the only opportunity would be to use the standard teleconferencing rules. And because that requires posting notice at your location 72 hours in advance, it's something that you need to discuss with the city manager and city clerk well in advance so that they could prepare that agenda, but that's totally doable. I've seen it happen all the time. But if you don't have, a good faith basis for a emergency circumstance or just cause, then
You're not-
those wouldn't be available in Vegas. Although you could go to Vegas and then have an emergency.
Or you could just tell them you're not gonna be there.
Or you could just not go to the meeting. Correct.
Yeah, but I mean, it kind of was a little loose during COVID, but
Thank you.
it makes sense to get back to, you really need to show up.
Yeah, I think that's where you're probably going to see the most immediate effect on these changes, because I mean, a lot of us have got used to, not necessarily here in city council, but some of your other committee assignments or other ones that are guided by the Brown Act. It's been just really easy to participate via Zoom. But it's going to be required that those are going to have to go back to in-person meetings, and those provisions of AB 2449 are going to apply to those entities as well if they're guided by Brown Act.
Right. And there's there are a little bit different limitation on use when a body meets less than 10 times a year, I think. And I didn't provide that information because that's just geared toward this body, which meets much more.
I have a question.
Go
So
ahead.
I've seen some information, articles and such that talk about the question of telephones on the dais and such, as if the concern is that members of the body are communicating outside or having some discussion. I suppose that's not exactly what you've been talking about, but it is conversation going on that isn't directly in front of the public, because it's going on during the public meetings. Do you have anything to offer around that?
Yeah. As I said, text messages can be the means for serial meeting. Perception is often king here. Text messages from constituents while on the dais raises a number of issues. There are certainly agencies that ban cell phones from use on the dais at all, from even having them. The issue is about secret communications during a meeting when the whole point of the meeting is that it's open and public. So the reason why there is a Brown Act is so that everybody can hear what you're saying, what the public's saying, what I'm saying. And so if there are text messages, that is a secret communication that the public can't comment on. So it definitely is an issue. There's also, depending upon the type of hearing, if the council is sitting as a fact finder and you've got due process that's implicated, then are you having an ex parte contact with someone? And text messages, whether they're on your private phone or whether they're on a city issued device, if it's about city business, I don't think it is, but it could be argued that it's a record that someone could ask for. So those are all things that any member of a public body needs to consider when they're texting from the dais.
Any other questions?
Well, so along the same lines, let's say we were talking about some highly technical thing like, say, EMF and blah, 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 and we don't know the distance between 5G and someone goes, hey, Kenny, I just want to let you know that and they send that to you and they say, oh, I just got a text message from an expert from the regional whatever, and he says that it's, 479 feet. And so you would introduce that so that everybody would know in that form, so that it would be some valuable information to the meeting. And it wouldn't be something that you kept secluded from everyone else and you would just make it known.
Right,
that
yeah,
time.
and which is exactly what you would do with an ex parte contact.
Yeah.
right, if there was that communication, the way to cure it is to disclose it at the meeting.
As opposed to them calling in on the regular number and they just happen to, they know your number or Stacy's
Well-
number and they called in and said, hey, just for your information, here's the information that you're discussing. And I thought you might want to know.
Probably the way that would be, one of the best ways to handle that would be to suggest that the individual provide the information in public comment so that everybody can hear it and that you don't have to be a conduit. And because, if that all happens after public comments close, then open it back up potentially if there's new information. So I would suggest that you tell your constituents to just provide that information that they have that you think is valuable during public comment or before the meeting would be even better.
Anyone else from the public? Anyone online?
No hands raised.
Okay, bring it back for any other questions or comments. Thank you, David.
Thank
Thank
you
you.
for the opportunity.
That was
to,
really good.
Does this count for